for today's brain gain. We're so excited to have Jodi Daniels here with us. Like, I just don't know if there's enough I can say about Jodi's professionalism and expertise in this area about cookie compliance and digital marketing, which is what she's going to speak to us about today. But she is an absolute wealth of knowledge about all things privacy compliance. She has her own consulting firm that she works with some of the biggest companies on problems and legal around this very topic. So we're really, really pleased and happy that Jodi is here with us today to answer your questions and shed some light on this very prescient topic. I know it's on many of our minds. And with that, Jodi, I'm not sure how you want to do this. I can either share the slides or I can stop sharing and you can share the presentation depending on your preference.
What if, since you already have it up, I'll just tell you when to do a next, like to move to the next slide since you already have them sharing. How about that?
Sounds great. Love it.
Okay. Love it. So if you can, well, first off, hi, everybody. I'm excited to be here and love that so many people care about privacy. Woohoo. If we can go to the next slide, have a little poll that if we can kind of look at some comments, it's not like a fancy poll, but just out of curiosity, maybe just share, are you one to opt into cookies being used on websites? Do you say yes? Do you say no? Do you say sometimes? And I did one of these yesterday and it was really fun to see all the different ones. So we have some yes, we allow, sometimes we have analytics, and it kind of depends on the sometimes. What really is underneath that question, that sometimes is a really important piece. And first off, thank you so much for participating in the poll. That sometimes is yielding a level of trust. If you click no, I won't, it's because you know a lot about what's happening and how that data is being used and you don't like it. Or if you pick, well, maybe, it depends on who the brand is because I might trust them or I might not trust them. And that's really important to the entire conversation around privacy because it's really about trust and what our end user, our prospect, our customer believes in us as the brand. So let's go to our next slide. And we're going to talk about privacy laws being the new norm. We're sometimes going to need to do some things. One more back. There we go. We're going to have to do some things because it's the right thing to do, that trust element. And the other is because we have to. This is not going to be an in-depth session on privacy laws by any stretch of the means, but I'd be remiss if I didn't say we're kind of in this interesting modern era of privacy laws. And it really did start with the EU's GDPR in 2018. Mm-hmm. There's a long list of privacy laws that have been in effect, including in Europe for decades before that. But what seemed to have kind of brought it to the horizon in modern day times is GDPR. And fun fact that you all hopefully know, if not, hi, newsflash, by the end of this year, there will be 5 US state privacy laws. And if you only heard of California and you're wondering, what about the other ones? Well, then let me tell you. We have California and Virginia effective right now. In July, we're going to have Colorado and Connecticut be effective. And at the end of the year, we're going to have Utah. As we speak, there are almost 24 laws being introduced in the United States right now. They're not passed yet, but other states are introducing privacy laws. Some are they have 2 privacy laws. They really want to get one of them passed. Globally, there's over 150 privacy laws. And there's this significant focus on the ad tech and analytics and digital profiling and tracking underlying all of these laws. So let's go to our next slide. A lot of times people think, you know what? Privacy, that's legal's job. Like whoever's responsible for law things around here, I'm just going to toss that over to them. But the reality is it's also, and sometimes first, marketing's role. A lot of times we'll receive an inbound inquiry from someone saying, I need to put this cookie banner on the site. I need a privacy notice, or it's an e-commerce company and they own everything on the site. And it's often the e-commerce manager's job potentially to understand what's happening. So whomever is responsible for the trackers, they have a stake in it. Whoever's responsible for the policy needs to make sure they understand what's actually happening in those trackers. And the reality is one person might be solely responsible to make sure that everything is being taken care of, but that person can't do their job without a cross-functional team. They have to make sure that they have everybody else as a part of it. And the other kind of interesting piece, and it's popping up more and more based on different trackers that are happening, is kind of trolls and class action lawsuits that are out there trying to really wreak havoc and take some type of law, tweak it to their benefit, and then slap the company with some type of lawsuit. What are some of these examples? If you've seen Chick-fil-A in the news, they had a Facebook pixel, for example, that is on their videos, tracking and being able to target. That data goes back to Facebook, and the plaintiff's attorneys say, oh, that violates the Video Privacy Protection Act. If there's a chat bot that's there, there's a lot of information that the chat bot company is getting, also could have some trackers. Those are wreaking some attention. And then I've seen clients receive some of these, and it's easy to do anywhere in the world, testing out the different cookie banners. Are they working properly? And if they're not, then someone sends, a mass message to a whole bunch of companies, sees what happens. And so if the idea of a law didn't encourage companies to pay attention, a lot of times the trolls will. And if we go to our next slide, it really ties to my very first poll question that I asked you, which is about, what is your sentiment? Would you trust the company and opt in to trackers or some type of cookie? Well, here's just a few stats. Our consumers care. Our prospects and customers care. If you're B2B, the person on the other side is still an individual. They don't always wear their B2B hat while they're browsing the internet. They're an individual and a human. And at the end of the day, humans are making decisions on B2B and B2C products. So we have, more than 2/3 of people not liking what's happening online. There's almost everybody, apparently a few dissenters who don't think that privacy is important online. I'm sure there's like one or two that just wanted to, pick a random one and mess up the survey. But then here's kind of the fun part. Almost 1/3 of people say, no, like I'm willing to share my data if I get a more personalized ad experience. Like I said, there's a long list of different statistics I could share. All of them share a view that people care about privacy. So let's go to our next slide. What happens if you don't comply with the law? Let's talk about some headlines. So let's go one more. One more. There we go. Sephora was the first CCPA enforcement action. This took place in August of 2022. What happened? Well, Sephora utilizes analytics and targeted advertising pixels on their site. And they did not disclose that they were using this data as considered a sale of data under California. We're going to talk about that in a moment. But because they didn't classify it as a sale of data and the state of California viewed that what they were doing was a sale of data, they were slapped with a lawsuit, with a enforcement action. They also didn't do something called global privacy control. You might be familiar with global privacy control. For those of you who aren't, if you knew of the idea of do not track, that was here more than a decade ago, but it went kind of nowhere. This is the modern day version of that. And basically, you have at the browser level, the ability to signal, don't track me. California, as well as Colorado and Connecticut, want you to be able to listen to that signal. Sephora didn't listen to the signal, and they also got in trouble for that. The dollar fine that they had to spend was $1.2 million. The word on the street is the legal time and the legal cost was well more than 1.2 million to get to 1.2 million, plus all the internal time. And these are the real headlines that came out. I don't know about you, but I probably wouldn't want this to be the headline about my company. Instead, I'd rather it to be, look at all the great new products I have, or here's this awesome new brand I just brought to my store. These are expensive lessons, and in them really set the precedent and stage for what we expect. Now let's go one more and just see a couple other headlines for where we are. And if you utilize anything, so this was Home Depot in Canada, where they would ask you for your email to get a receipt. Many people say, yeah, that sounds great. I'll get an email. Then they took the email and uploaded it to Facebook for targeted advertising. Because the language said, no, I just getting a receipt. It didn't say anything about the marketing piece, and I didn't consent to that. Those in Canada and the Canadian regulators didn't really like that, so they got in trouble. Now, they're very nice in Canada, and they didn't receive a fine. However, it sets precedent for anything happening in Canada, and they do have a long list of other things that they have to do. And then, this wasn't really a great headline for them either. I do these headlines all the time, and I pretty much have concluded Facebook could probably always be in the bottom left corner. They're always in trouble somewhere around the world for privacy. I just mentioned the Chick-fil-A piece a little bit earlier. This is very common. They are targeting big companies on this Video Privacy Protection Act class action lawsuit with trackers in the video. And then, what's kind of also interesting is GoodRx that took place about a week or so ago, where the Federal Trade Commission kind of came out and really was looking at the unfair principle here, saying, no, you cannot share health data with third parties for advertising purposes. And actually not really just the unfair piece, but it really was going back to the health breach notification rule, where it says you can't share this kind of sensitive information for advertising or for other types of purposes. And it wasn't disclosed that this was happening, and so they got in trouble. This is a really big deal that the Federal Trade Commission is looking at some of these other powers that it has to try and look at what's happening in a privacy landscape. With all that background, we have laws, we have fines, we have branding and press, and we have people who care. Let's now get into some of the nuts and bolts on what is a sale of data and kind of the world of cookies. So if we can go to the next slide, that would be awesome. Actually, next two slides. So let's talk about kind of sale of data and cookies and trackers. The first one right here, a lot of times people think, oh, it has to be a significant amount of personal information to qualify as personal information. It has to get tied together. It doesn't. If you just had my name, or you just had my email, or you just had an IP address, that could all be personal information, because typically that IP address might be tied to be used in some other fashion. It's being connected to something to do something. The browsing history in itself can be considered personal information. And I think that's really important to understand, because it shows up in the disclosures that we have, in the options that we have to opt out, in the ability to use that data. And globally, do we need some type of business purpose or legal basis to be able to use the data? And I will often talk with companies and they'll say, oh, well, but I don't have credit card data, or we don't have health data, or we don't have birth date or socials. We just have name and email and browsing history or cookie. I'm like, awesome. You have personal data, just maybe not as much as somebody else. It all still counts. On our next slide, I have pulled the specific definition of sale and sharing of data. Now, let me also, this is a great place to explain the acronyms. All industries love their acronyms, no different in privacy. In privacy, we have CCPA, California Consumer Privacy Act. That is what was effective January 2020, and it passed in June of 2018. Well, fast forward, November of 2020, maybe some of you were in California and you went to the polls. You voted yes or no on a privacy amendment, and it was known as CPRA. Today, it's CCPA as amended by CPRA. So kind of same thing. If you hear the different acronyms, they're kind of all tied together. CCPA introduced the definition of selling. CPRA introduced the definition of sharing. And as you can see, they're really crystal clear on what it is, right? Really short, concise, clear as mud. The pieces that are really important are where it has not for monetary or other valuable consideration. because this is where Sephora got in trouble, and many other companies are having to deal with the right disclosures and opt-outs. Because essentially, if we can go to the next slide, ad tech is deemed a sale of data under CCPA as set by the precedent in the first enforcement action. It's been said multiple times by the Attorney General. It's been said multiple times by privacy attorneys. And this is kind of a California thing, but globally, remember I mentioned how ad tech is a really big focus of people around the world. Well, if you comply with GDPR, people will say, oh, I'm all done. I don't have to worry. Actually, you do, because the sale of data is this very unique CCPA thing, and GDPR doesn't cover it quite the same way. What do you need to do? Well, if you're using pixels where the other party can use the data for their own purpose and own algorithm, it's been deemed I shared that data with that third party. I sold it to them. They get to use it for themselves. Therefore, I have to, one, disclose in my privacy notice what I've done. Two, I have to have on the footer of my homepage, do not sell my personal information. And three, I have to make sure that I have in any of my cookie opt-outs the ability to opt out of the sale of data. So let's talk a little bit more about cookies. This should probably be no surprise to you, but let's look at some of these. There's kind of 4 typical categories. Sometimes people expand these. Sometimes people have slightly different names, like strictly necessary, preference cookies, statistics or analytics cookies, and then, all things marketing cookies. You want to be able to have these types of cookies. And I've seen different examples. Some companies really like the cookie list. Some companies like the ability to see the cookie list, but in the cookie tool. Some people are also having this banner here, but if I click do not sell my personal information in some type of cookie software tool, then I should actually be able to just have like strictly necessary and then sale of data. All this to mean your cookie installation or cookie software installation is really important, the kind of cookie consent tool you're using. I see a lot of companies try and build one. I highly encourage you to find one of the more than 100 cookie consent softwares that are out on the market. That's their job, is to keep up with all of these. And remember, I said we have 5 privacy laws effective here in the United States, and there's 150 around the world. We're going to have more complexity and nuance, and that's the software's job. And I like to have my developers, implement these things as opposed to building cookie tools. So that's my personal preference. If we go to the next slide, let's talk a little bit about the difference between the US, and I'm just going to pick on the EU, but the reality is you could honestly pick almost most of the other countries outside of the US, because the reality is most of those are an opt-in situation, except for strictly necessary, and strictly necessary needs to really be strictly necessary for the function of the site. Otherwise, the function goes kaput. Not because I really need it and I really want it. That doesn't count as strictly necessary. In the United States, despite all of my disclosures and opt-outs, right now, it could change, we're really an opt-out situation. Those are vastly different. And in your cookie consent tools, you can set this all up for however you want. Now, Jodi in Georgia, I have nothing unless any of you just care so much about me and want to give me the option. If you do, you could have a different banner for me than you do the people in California or the people in the EU. You kind of can decide how you want to set that up. If we go one other page, might actually move this one a little bit faster. So yeah, let's go one more page. You're all probably very, very familiar to be able to figure, so stay right here. Thank you so much, Kayla. The prior page, you're all probably very familiar on how to find those pixels and trackers, but keep in mind that your customers can too. And the idea of using a tool like Ghostery or figuring out how to see the code and trackers, that's happening a lot, including those plaintiffs' attorneys that I said who want to go out and figure out where your cookie banner is set up the right way. They can see that too. Here are some fun facts on what you want to make sure you're doing correctly for cookie banner do's and don'ts. From a cookie policy perspective and kind of like the banner, we're seeing a lot of, now first off, this is not really the best cookie policy. Here, it really was focused on accept and reject and manage settings. I wanted you to see the idea of how accept and reject have the same what's called symmetry. One's not colored more than the other. One's not smaller than the other. You really want to be able to make them even. And that is guidance that we're seeing out of the EU and out of California. That dark pattern is very important. People don't like being tricked, and regulators don't like companies who try and trick so that they can get what is beneficial to them, not beneficial to the end user. Listing the cookies, often in some type of consent tool. And I am seeing cookie policies kind of make a comeback. I feel like they came, then they went, now they're kind of coming back again. Think about the mobile experience. I have experienced some where you can't even get past the cookie banner. I can't do anything unless I'm forced to accept, and it's ruined the entire experience. That is not how cookie banners are supposed to be working. And again, you really don't want someone to be forced to accept. Cookie banners don't have to be boring. They can be cool and fun, like these next brands that I want to show you. Starbucks and Coca-Cola have some really cool brands. And what they've done here is they've kind of played with their experience. And I encourage you, hopefully from now forward, you're going to look every time you go to a website and see cookie banners and screenshot them just like I do and say like, oh, that's really cool. Let's go see what happens. But I really do invite you to see how can you work with your teams. Maybe you are the team, or maybe you have some colleagues who you can work with to make these things, and privacy be part of it and not just this compliance activity, but to make it be a good experience for the end user. Because at the end of the day, privacy is about the end user. It's not just a compliance piece. A little bit more on what cookie banners should say is on our next slide. Here are some tidbits, really making sure that it's explaining. So one more slide, making sure that you're explaining, are you doing advertising, analytics, and social? Do you have a link to be able to change the settings? Do you have a link to the privacy policy for more information, or the cookie policy? Don't forget about the accept and reject requirements and the do not sell my personal information piece. And it really isn't okay to just say, hi, we use cookies, thanks for accepting. That's not really where we are today. From a compliance standpoint, and remember where we started, which was that polling question. Would you opt in or not? Why do people care about privacy? We want it to be a conversation with them. And when we just say, hi, I use cookies, thanks for hitting the okay button, it kind of makes the banner moot. It doesn't give them any choice. And they don't actually feel like they should trust your brand because they had no choice in the matter. Let's go next to global privacy control. I don't know if you're familiar with it. If not, I highly encourage you to go to global privacy control. Of course, after this conversation, you wouldn't want to miss all the fun we're having, but go to global privacy control, see what it's like as a user and then as a company. And as I mentioned, in the United States, there are laws that are requiring companies to be able to adhere to the signal. And a lot of the cookie software tools are advancing to be able to help with this requirement. Sometimes I've even seen some. So when Jodi shows up at the page, I have GPC flagged. It'll show up with a little banner that says you have this turned on. And sometimes maybe I trust your site and I'm okay with trackers. I can toggle it off. There might be that situation. Maybe I've turned it on because I just don't trust anybody, but I'm willing, actually, I kind of want those like cool sale coupons you're going to give me. So let me turn it on. Or I like you. It's okay. You can, measure me. And so highly, again, the cookie software tools will help you with this implementation. And then make sure everything I've described is disclosed in your privacy notice. So you want to be working with your, whoever writes those for you and work with those teams. One more page, I wanted to show you kind of one in practice of what a do not sell my personal information and financial incentive link kind of looks like. Financial incentives, maybe not as much, but if any of you work on loyalty programs, this is a really big deal in the loyalty space. Also some special provisions out of California. But here's an example of do not sell my personal information. Yesterday, this comes from Pottery Barn or Williams-Sonoma, if you want to check out what the experience looks like. I saw Gap has actually also a really nice one that you might want to look at. And going forward, just like those cookie banners, go check out do not sell my personal information links. What you will find is actually very amusing because they're all super different. And no, don't go copy someone else's without making sure you're understanding, will it really work for you? Now, I know that Google Analytics, because I saw some of those questions, was really interesting. So let's kind of switch gears a little bit. This is going to be a pop quiz. Does anyone know which countries Google Analytics is deemed illegal? So Kayla, we can share this next slide. Does anyone know where Google Analytics is deemed illegal? Feel free to pop it in the chat. Austria, Sweden, Italy, Denmark, Spain, Italy, Germany, all good ones. So the answer is on the next slide that Kayla's graciously going to share with us. And it is Austria, Denmark, France, and Italy. Now here's the deal. There's a lot of companies still using Google Analytics in all of these countries. It is my job to tell you that these countries don't like Google Analytics. At the same time, there are a lot of companies willing to take that risk and continue to use them and hoping for the best. Other companies are choosing to see some alternatives. And I wanted to list some of the kind of more GDPR friendly ones that a lot of privacy professionals recommend if that might be of interest to you. So when it comes to kind of the world of Google Analytics, it's a little bit of a messy one because, as I said, there's a technicality, there's a business risk that is here. So you're going to start to probably see some companies move to these others, but like everything, Google Analytics in Europe would be opt-in. You want to make sure you have the right opt-out language in your privacy notice. And something that I see a lot that people don't always appreciate is Google, like many other of the big tech players and some of the advertising players, require you to specifically have not just a cookie opt-out, but an opt-out with a link to their platform. Google Analytics has language that you need to include in your privacy notice. And that was agreed upon in the terms that I know all of you read, all like 4,000 pages of them. But in all seriousness, do make sure that anytime you're using some type of tracking technology, that you've determined, do you have to have a special disclosure in the privacy notice? The answer very well might be yes. And I want to go back because I wasn't looking at the chat. I was so excited about having this conversation that someone asked a question. I wanted to address it. The color scheme is guidance or legally required? It's not that you are required to have a certain color scheme. You can pick the color scheme that works best for your brand. What is required is to have it not be a dark pattern. And a dark pattern is often where you make it easier for the user to see a particular button that's going to be advantageous for you, the company, and not me. So if you want me to opt in, you make that one bigger font, really bright colors, really great, beautiful, and you have me do that. And the like opt out button is smaller or drab or hard to read. That would be a dark pattern. The idea of symmetry in choice is this idea of not having a dark pattern. And that's where the colors are created equal. The fonts are created equal. The boxes are created equal. Even a line around the box can be considered a dark pattern because the eye naturally goes to, oh, there's a line around the box. Maybe I'm supposed to do that. The same with opt-in is often the right-hand picture because the eye often goes to the right and picks that one. So those are all things that you want to think about from a dark pattern / user design experience. Great question. Let's move to kind of our last segment here, and then we can open it up for any other questions, which is privacy data and de-identification. I know that this kind of comes up, and the idea being, well, I really want to utilize all this information. Can I? What can I strip from personal information that will leave me with a pile that I can do something with? And the reality is, if we go to this next slide here, if data can be reunited with personal information, it's not de-identified. It's not anonymous. It's not de-identified. If I can be reunited with it in some way. We were working with a customer and they, want to pull out information to be able to do all kinds of analytics. And what they're trying to do is figure out, well, what information can I strip? So I'm kind of left with, really just a pile of data. And they had an account number. Well, in theory, that account number could eventually be tied back to somebody through their systems, and that really wouldn't make it be de-identified. So you want to be thoughtful to what kind of data you have and how you're able to strip it to be able to truly make it in its own separate universe and make it anonymous and de-identified. Something to think about is when you're going to use personal information. In Europe, they have something called a legal basis. We're most often familiar with consent. You might have heard of something called legitimate interest. The last one you might rely on is called contract. There's 3 others that pretty much everyone in this room would not rely on, like benefit of the public interest, public health. So things like that. Consent, legitimate interest, and contract are the 3 most popular that kind of show up in a marketing and data universe. In the United States, we don't have that specificity. Instead, we have popping up in our new state privacy laws, business purpose. What is a business purpose? Well, that's a great question. If you collect it the first time and you have a business purpose, then you have to say in your privacy notice how you're going to use that. If you're going to collect that information and then you want to use it for some secondary purpose, depending on the kind of data, you may or may not be able to do that without consent. Let's just go to our health data. Many of you might be working in a company and there's health related data. If I give you that data to give me my product and service, that's business purpose 1. If you want to use that data to go create some type of research paper and share it with the universe, that's a totally different purpose, and I might have to consent to that purpose. If you have other sensitive factors like race, religion, gender, biometric data, anything along those lines, and there's a list of some other sensitive fields, that too might need to have some consent to it. When it comes to sensitive data, they're not all created equal. Just like cookies aren't all created equal. I'm sure that surprises all of you, but all the states have different views on how to make sensitive data. We have some states where it has to be opt-in, and we have some states where it's more of an opt-out business purpose kind of thing, and I get to limit how you're going to use it, which means you really need to know the data that you're collecting, what it says at the time you collected it, and how you're going to use it to be able to make all those decisions. And just keep in mind, kind of like how I explained personal information can be just name and email. Sensitive information is often thought of as health or financial data like a credit card or a social security number. And sensitive data in all of these laws are much broader. I shared a couple examples: race, religion, political views. Those are all sensitive data fields, plus a variety of others. So make sure you understand your data and work with a privacy professional to be able to determine, does this impact you at all? And the last part I really wanted to make sure everyone was paying attention to is every cool new tool, whether it's a tracking tool, a software tool, it's a vendor, it's a third party who's going to do any of this for you. You want to make sure that you've considered privacy. You want to have a really strong contract in place so that it's clear what they can and can't do with it, how they're going to protect it, how are they complying with the privacy law on your behalf. All of those are questions that you want to be able to ask. Again, whether it's an agency who's going to have access to your data or a new tool that you're going to be leveraging. It's really important that you understand that. If we go to this last piece, this is kind of how we look at privacy. And I wanted to help you kind of figure out where this slice fits in what we call our privacy ops framework. The idea that there's governance, someone paying attention to privacy, maybe that's you, maybe that's a team member. You have policies and standards, that's the external notice. You might also have some internal notices, or maybe you have a marketing framework, or maybe you need one. The idea of a data inventory, you might have a slice of that pie. This is really all about, imagine we were at a whiteboard going from left to right, documenting all the data at a business process level. I use Google Analytics so I can figure out, how many people are coming to my site. We use emails so that we can send messages to them. Oh, and then we take those emails and we do custom audience marketing. See, email was used 2 different ways. We want to be able to understand those use cases. You might have to do privacy impact assessments. It's a fancy word for figuring out what are the privacy risks that you have in your organization. And some laws require them. Hint, hint, targeted advertising in Virginia and the EU require them. Individual rights, this is choices. Jodi gets to opt out. Jodi gets to ask you to delete. Jodi gets to ask you for access. Give me some choices. Vendor management. I talked a little bit about that. Do you have an idea of who your vendors are? Just got an inbound request this morning from a client saying, hey, can you help us stand up a vendor program? We're ready. We're time. We got all this other stuff as our foundation. Now we're ready to move on. Marketing consent and preferences. What choices did you give me? Is it opt-in? Is it opt-out? Anyone here try and unsubscribe from an email? But you actually would kind of be okay if you could stay with the brand. You just don't want them like 5 times in one day on the shoe sale. Maybe once a week would be better for you. That's preference management. Security, underlying privacy is security. You can't have one without the other, but they are vastly different. Training, thank you for showing up and learning more today. Make sure you share the knowledge and the wealth with all of your team members and new hires that come on board. And then the idea is that this is foundational and we rinse and repeat because there are more laws coming. There are more cool new use cases. I just got off doing a podcast on AI, right? That's here. We can have I'm sure you're going to have a whole conversation on that, but there's big privacy impacts there. And you want to make sure that you think about all that. Hint, hint, you see how it's across from the privacy impact assessments? That's where that piece shows up. Isn't that fun? I am delighted that I could talk all things privacy. I want to make sure we open it up for questions here. And the next 2 slides are how to learn a little bit more. If you thought this was fun, I have a book, Building Trust One Bite at a Time. It's a cool bestseller and you can grab it on Amazon, Kindle, hardback, paperback. Go to my website, find it somehow if you thought this was fun and interesting, with all kinds of interesting stories that are within it. It is meant for the business person to be able to understand more about privacy and security and how it relates to you personally and in your business. And then the last slide is just me and would love to connect with you. I mentioned a podcast. So I host a podcast. She said privacy, he said security. Again, if you find this fun and interesting, and here's all my contact information. Thank you so much. And again, I'd love to open it up for any other questions.
That was fantastic. Thanks, Jodi, so much. Just wanted to say that.
Pleasure.
Yeah, really, really fantastic.
Yeah.
So what I'd like to do now is, I know that we've had some questions come through in the chat. And if you feel comfortable, you can raise your hand and come off mute and ask in person. And then we can also take some questions from the chat. So Christina, I see that your hand is up. You can go ahead and come off mute.
Hi there. So as you can probably tell, Jodi, from the accent, I'm based in the UK. And so my query is about where they're making a decision on compliance. So your example of French Google Analytics, as a Brit, I frequently go to US news websites and just find I'm totally geo-blocked thanks to GDPR. And they're just, I think, things like The Atlantic, their decision was just no traffic from Europe was how they handled it. But in Europe, how are they determining whether, should I be blocking Google Analytics on my website, which is hosted in England, is a UK legal entity that runs the website? Should I just block French traffic with Google Analytics, or does it only apply to websites owned by French entities hosted in France?
That's a great question. And it kind of has a global answer to it, truly no pun intended, which is that all these laws really apply to where the person is, not necessarily to the whole company. I always find it super unfortunate when a business blocks a whole region over privacy laws. I appreciate their business model and their decision to do so. I still think that there's workarounds to be able to try and still do business in a particular area and be privacy friendly. So in this situation, it would really be more about the French traffic, not necessarily that, Jodi in Italy, well, no, not Italy, Jodi in Australia, can't have it either. It's based on the traffic. And that is a true statement for all these laws. So like I said, Jodi in Georgia, I get nothing. I have no privacy rights of any variety. My dad in Florida actually called me once and was very adamant and mad about a company using his data. And I said, well, Dad, I'm really sorry. You have no privacy rights. He's like, what? This is terrible. I said, well, you can move to California and you'll have more rights. So really it's about where the people are as opposed to where the company is based. And then it's just up to the company to make the decision. Should they do something or should they not do something? So in your situation, you could block French traffic, but everybody else who's allowed to have it, have a field day. A proper field day, of course, with, all the other things. And you in the UK have all kinds of extra fun because you have a UK GDPR that essentially copied the EU GDPR, but you're in the process, not you, but the UK is in the process of updating and trying to amend that to make it its own version. And it will make it, they'll ultimately probably lands kind of in between the US privacy laws and GDPR. They're trying to downgrade from GDPR, but like more than California. It'll be interesting to see where that lands.
Thank you very much.
Sure.
Mitch, I see your question in the chat. You're welcome to come off mute if you'd like to ask, or we can just address it here. I can read it.
No, I can just ask it. So kind of give a context. So I work for a state university. Thanks for giving context that Utah's getting the privacy law because I'm based in Utah. I've been actually working on this for like the last month and a half. I got hired into my position as a marketer, and I kind of just looked at our website and saw all the things that are happening with privacy laws and was like, we need to become compliant. So technically I'm working with our legal team right now to review the capacity of doing Google Signals, which is the remarketing capacity. So I kind of had like a two-sided question, which was, how does the Google Signals with is the additional information that's added, which is like age, gender, and interest, considered personally identifiable information? And then what's just your experience with having to deal with US companies wanting to implement Google Signals or having a little bit more of a remarketing? I'm kind of in a weird scenario because I'm actually for an academic institution. So I'm for, a university. So it's kind of, we may have the potential of getting students all over the world, but we also are mostly focused in Utah. So it's kind of a weird blending. So I just wanted to kind of get your experience off of seeing that.
My answer is going to be similar to what I just shared before, which is that first, the answer from the global piece really has to follow your overall scope consideration for, are you in scope or are you not globally? And if you accept students, if you engage with them, if they're participating in webinars, emails, things like that, my guess is you probably have determined that they'd be in scope. And so for anyone else listening, just to make sure it's applicable, you need to understand that scope. If the law wasn't written to get every single individual on every single website because Jodi was great at search and found you on page 23, it's meant to be, is your organization truly in scope for that individual that you're targeting and messaging? You have to kind of look at that scope piece. So let's assume that yes, they are in scope. It would follow just like any other tool in any other area. It's just a different kind of tool. You would want to follow the same measures from an opt-in and a disclosure and the ability to opt out situation. How is that data getting used? How is it getting connected to anything else? It's going to follow the same scenario. In the United States, it's also the same scenario, but as an academic institution, you're actually in an interesting place. I don't know if you're for-profit or not-for-profit, because not-for-profit is technically excluded in the United States, with the exception of Colorado, who includes nonprofits. You might decide you want to participate because that's just, you don't feel the difference, which is kind of Colorado's view. They're like nonprofits. Some of those are bigger than corporations. We should include them. Others are, nope, this is just for businesses. So it would be the same philosophy of having the right disclosures and connecting that data to any of the other data that you'd be using. In my mind, Google Signals is going to be really similar to any other kind of data that people are using in clean rooms, buying data, third-party data brokers, all of those. Kind of the same philosophy. Determining can you use it, the kind of data, the matching, the disclosure, and the opt-out. So I hope that addresses your question.
Perfect. Thank you.
Sure. I see someone has a hand raised.
Yeah, Jay, go ahead
Jay.
and come off mute.
Yeah. How does is there any difference in how this stuff is applied between client-side cookies and server-side cookies? Or is is there no difference?
So some people are trying to make that be a difference, but the reality is it's about who's collecting the data and what is happening with the data. That really is what it's going back to. If it's a data point that is going to a third party and they're going to be utilizing it for analytics and third-party advertising somewhere else, it's acting in the same capacity. If it's your own proprietary cookie and it's going to be used, in one fashion, then it is going to follow again, regardless if it's kind of client or server side. So it's really about the intent of what the cookie is doing that needs to be the decision point as to what you need to do with it and what kind of cookie and what kind of disclosure. And the sale piece is very much focused on what can that third party do with that data.
Got it. And so is that why countries like France have entirely outlawed Google Analytics because of what Google can do with the data once they have it? So it doesn't matter if it's Universal Analytics or Google Analytics 4. It's just the fact that Google, in whatever their terms and conditions are, they have some access to this data.
That's exactly it. They don't like that Google has access to that data. And the bigger philosophy is overall, there's a significant concern on government access to that data. And then how a company like Google can tie everything together and still be able to figure out Jodi's profile and Jodi's tracking habits. And they're using the data to help build their algorithm. And for those reasons, they don't like that. If Google didn't do that and they just, kept it in its one little place, or they didn't ever have access to it, it would likely be a very different scenario.
How is this affecting small business owners? I'm sorry if I'm using too many questions, but how is this affecting small business owners who maybe don't understand their scope? They go to GoDaddy, they spool up a WordPress site, they slap some e-commerce on it, and all of a sudden they're selling products in US, Canada, Australia, and parts of Europe because, whatever, they just go to Google, they pay for an ad. Like there really is no clarity for the small business owners. Are they getting targeted by this, or is it like most of these like the California one where it's based on amount of traffic? How is that?
So it's definitely not based on the amount of traffic. GDPR has no minimum. Let me rephrase. The US has minimum thresholds for privacy, just like it does many other laws. Pick an HR law. There's always minimum thresholds for companies to have to oftentimes to adhere to, like benefits. If you're a certain size company, then you have to do this. Or if you're a certain size company, then you get a credit. Globally, there are typically no floors. It doesn't matter if you make $1, $1 million, $10 million, $1 billion. You're all in scope. Your point is very well taken, which is why the UK actually has a really big soft spot for small business, and they're trying to make some adjustments in their kind of new version. In terms of kind of regulations or regulators and where they're looking at really big companies, but they are also looking at little players, especially if they make a mistake, or the trolls out there and the people who just have nothing else to do but to go and find people and cause havoc. They can be a problem for the small business. Or you have a really privacy-minded individual who can do that too, because the sentiment here in the US is really very different than it might be in Europe, because they are a privacy-centric country compared to, or region, multitude of countries compared to where we are here. What I am seeing is, first, there's a long list of small businesses who don't know what they're doing, and they need to comply with privacy laws, just like they have to figure out how they deal with tax laws. And that's an area for growth for those e-commerce companies. Some of the platforms, like a Shopify, for example, where a lot of small e-commerce startups start, they have a number of different plugins. They'll have a number of different areas. And what we see is, as some of those e-commerce companies grow, then they honestly start coming to us because they're at a big enough place where they realize, okay, the like base level knowledge that I got over here isn't really working anymore. I have more complexity and I need more assistance. It's definitely an area that they have to work in. And in the United States, even though there's a technicality, what I would offer for anyone here, maybe you're at an agency or maybe you're at a small company, those small companies are trying to compete with big companies. And while they technically might not have to comply, they might choose to, because they want to look like everybody else. And the end user isn't studying privacy laws and has no idea. Oh, you're small? Oh, you technically don't have to comply. That's why Jodi in Georgia gets a cookie banner, because that company has either, one, doesn't know how to set them up by region, or two, decided, operationally everyone gets one, because why not? So that's something that we see. In fact, I worked with someone and they had a whole bunch of small Shopify sites who all were looking at Kim Kardashian's site, and they all wanted to look like her because she knew what she was doing, and they wanted to mimic that. The challenge with that is her privacy notice has all kinds of things that don't apply to these little smaller companies because they weren't doing some of the things that she was doing. And you want to make sure that whatever is happening on that company site is only relevant for that company site. So don't copy somebody else's privacy notice.
So what happens then when these mom and pop shops get dinged by GDPR? They get extradited to the EU to face a European court? Like, I don't understand how the EU are inflicting their laws on American businesses. Like, how does that work?
That's probably a more complex question because you start getting into kind of like international territories and how that all works, which I see Jeff's hands up. So I want to make sure I get back to Jeff. So Jay, it's a really great question. I don't mean to dismiss it.
Sorry, I took too much time, but I was really curious.
And I probably can answer right at this moment.
I appreciate it. I appreciate your time.
Sure.
It is a good question, but we had a question that came up in our forum that I thought that I'd ask here, and that is with some of the new developments with like BigQuery and Google Analytics 4, you can choose where the data is stored, which sort of gets over some of the international border crossing of the data. So you could, if you're an EU company, you can now choose to be on an EU server. You can do stuff like that. So that works, right? But what if the question was from one of our students, he said, what if I work with US companies? Would I be compliant with GDPR if I stored my US company's data in a European BigQuery? Would that be necessary? Would that sort of prevent the round trip of data, or do you deal with it on a case by case basis? So should a US company store their data in Europe just so they don't have to worry about it?
There's a lot of companies that are US based companies or global companies who will allow you or who want to store their data in the EU so that they don't have to deal with the cross-border movement issue, because that is a real issue.
Okay.
But it's not just a US issue, it's a global issue because there's only 12 countries around the world who get what's called adequacy, which means they can share their data back and forth, like our friends to the north in Canada. EU can get shared to Canada, have fun as much as they would like to, no issues, because the way Canadian companies have to deal with privacy is vastly different than what you have to do here in the US. If you have a US person who's going to access that data that's stored in the EU, depending on exactly how they access and what is happening with that data, you still might then actually bring back the cross-border challenges as well. And the big piece on cross-border is there's a significant concern on government access to that data, and then what the security measures are. And there are ways that you can work through that.
Okay, that makes sense. So the data is one thing; it's who accesses it, and so that's
another part.
That's a bigger consideration. So maybe you'd have to have two instances then, one in Europe and one in the US, and then
that wouldn't really solve it because you'd still have to figure out how to get the data over here. So that would actually duplicate, and then you would increase your security risk. So it's more about working through the cross-border issues, or having someone there, or having the data that's being accessed really limited, or having, the type of personal information that you're going to get that's limited. What we are seeing is a pop-up of some of the larger tech companies really being able to offer, and smaller companies, offer their data in the EU and setting up EU data centers.
I see. That makes sense. So, and that this only applies to personal data too. So it's not like everything needs to be proactively accounted for. It's personal data. So
that's right.
That's another good distinction.
Just as long as you look at the vast definition of personal data, but yes, it's just personal data.
Awesome. Thank you.
Yep.
Awesome. Well, we're just about at time. Jodi, we can't thank you enough for coming here today and sharing all of this invaluable information and taking the time to answer our questions. This is a truly fantastic brain gain session. So thank you all for being here. Thank you, Jodi. Next week, we're going to be having some of our own members present. Chris McCain and Chris Freeman are going to be talking about site speed optimization. We're really excited about what they're going to be sharing with us. And that's it for today. And we'll see you all next Wednesday. And thank you again, Jodi.
Thank you. Bye, everyone.
Thank you, Jodi. This is the best. Appreciate it. All these are the best, but this
Yeah,
is
this one is especially the best.